All right. Good morning, everyone. I think we'll go
Good
ahead and
morning,
get
Colin.
started with folks who are here, so we can be respectful of people's time. Wanted to welcome everyone to our subrecipient training. As many of you know, when HUD monitored the city of Durham for its ESG-CV contracts, there were multiple findings, and to clear many of those, there are some trainings that everyone is required to go through. So we have partnered with Apt Associates, and Megan Takashima and Whitney Patterson are joining us today. They are the experts on all things ESG, and they have graciously agreed to work with us to provide the first round of training on HUD required topics that we need to get everyone trained and up to speed on. So this is part one. We will continue these trainings later in the month, probably the 28th and 29th. Those mornings we'll send out an invitation for that. So with that being said, I will turn this presentation over to Megan and Whitney. And please feel free to put questions in the chat. This is meant to be interactive, as we want everybody here to get as much as you can out of this and have any questions you have answered, as we don't want anybody being confused or having issues down the road if HUD ever comes back to monitor or when we come to monitor. So with that being said, thank you, Megan. Thank you, Whitney. The show is yours.
Thank you, Colin, and nice to meet all of you, and thanks for joining us. As Colin said, feel free. We want this to be interactive. We have a smaller group, so you're welcome to ask questions, put them in the chat. But let's start with a round of introductions, if you don't mind. So if you don't mind just using the chat to do this, we'd love to get your name, your pronouns, your organization, and your role in the chat. And just because we have a smaller group, I thought about maybe we should do an icebreaker. And I'm not sure what it's like in Durham right now, but we're finally starting to get some fall temperatures where I'm located in Michigan. So I'm curious what everyone's favorite fall food is. So if you don't mind adding your details, but also that information in the chat, that would be great. And just a quick bit about me, and then I'll let Whitney introduce herself. So I don't proclaim to be an expert on all things ESG, but I have worked in the role as an ESG recipient. I did that for about 5 years with the city of Detroit, so kind of led our ESG program. So do have some familiarity, and then I've been working in technical assistance for about 3 years, and work a lot with ESG recipients and did a lot of the work around ESG CV. So looking forward to kind of supporting all of you with this training today. And I'll turn it over to Whitney real briefly, just so she can introduce herself as well.
Thanks, Megan. And if Megan doesn't assume that she is an ESG expert, then I am by no means an ESG expert. She is much more the leader in this area, and I'm really glad to have her as a partner in this work. I also work at Apt Associates, and I am assigned long-term by HUD to your homelessness system. So whenever needs like this come up, either across the system or for individual providers, we're here as a resource to you all and really want to provide the support and connect you with whatever subject matter experts like Megan would be helpful for those things. So thanks for having us.
Okay, so I think we're going to jump in. And as I said, we'll be monitoring the chat in case questions come up. But wanted to just talk through quickly what our training objectives are. And really, there are 3 things that we're going to train on today. We want to make sure that all of you understand some of the requirements specific for record retention, conflict of interest, and duplication of benefits. And at the end, we'll do a very exciting quiz where you can test your knowledge just based on your existing knowledge and anything you learned today. But I don't think that'll be a high pressure thing. But those are the topics we're going to cover today. And well, I think we'll just go ahead and jump in with record retention. And so many of you may be aware of this, but all records pertaining to each fiscal year of ESG funds must be retained for 5 years after the expenditure of funds and that's except in the case of a conversion or renovation of an emergency shelter. I think if I understand correctly, that's not a common occurrence, or that's not something that has happened recently in Durham, but we'll talk about that separately. And when you think about record retention, copies can be made by microfilming, photocopying, or similar methods, and may be substituted for original records. So there is the opportunity to kind of do remove sort of the paper file and do things electronically. And we'll talk a little bit more about what requirements exist around that. And then all recipients and subrecipients are required to have a record retention policy. So as a subrecipient, and this is true for ESG in general, it's important that you have some sort of record retention policy in writing that you can share should you be monitored by the city. And so that's something, there are a lot of sort of, examples online that you could modify. It might be worth looking at the policy that the city has to help you with that. But if you don't have one in place, that's something that you're going to need to get into place. So, getting down to the specifics of what must be included in a record. So if you're serving someone, with any of the ESG allowable activities, there's a number of things that need to be included in your record. You're going to need to have the homeless or at-risk status. You need to verify that and provide written documentation. And that follows the written intake procedures at 576.2. And so many of you are probably aware of those, familiar with those. But, we did put additional sort of support in here in case there's questions you have. And I imagine, I don't think we said this, but we could share this document so that, if you need to reference things, you have access to them. You also need to put determinations of ineligibility. So if there's someone that is screened for the program and they're not eligible, you do need to keep a record of that. So even if they're not served by the program, that's something that you would need to have. You also need to have annual income. And this is specific to the rental assistance programs. Yes, Lloyd, you could maintain your records in HMIS. The requirement would be that you're able to access that information. We'll talk a little bit about that, I think, in a couple of slides, but that's a good question. As it relates to annual income, for each program participant who receives homelessness prevention assistance, or anyone who receives rapid rehousing assistance for longer than 1 year, documentation of annual income must be maintained. So that's, I think, a distinction there. That sort of reflects the fact that there is no income eligibility for rapid rehousing initially, and it's only at the recertification point at a minimum of 1 year where you would need to gather that information. You also need to keep track of program participant records, and we'll talk a little bit more about the details of what needs to be included in that record. And I see this question. Yes, I think that's, since you do need to, the question is, if clients are determined to be ineligible for a project, would the suggestion be that these records are retained outside of the HMIS? And I think if your HMIS record is not adequate to demonstrate the determination about why someone was ineligible, then that's something that you would want to keep outside of HMIS. I think sometimes those records may be kept in a different place if you're using a physical record, just because it's someone that was screened but was ineligible, but you would need to have access to them. As you think about what needs to be included in the participant record, I think many of you who have worked in this field are going to know the details of this, but you need that homelessness or at-risk documentation. That's a big part of determining eligibility for ESG. And you do need to follow written intake procedures to determine whether program participants meet the homelessness definition or the at-risk definition, obviously homelessness definition for all of the different allowable activities outside of homelessness prevention. And these procedures require documentation and intake of the evidence relied upon to establish and verify homelessness status. So as we think about how you're going to verify that status, for all of the programs except shelter, the interim rule establishes this following order of priority. So the preference for establishing homelessness would be third-party documentation, So that could include written and source documentation. You know, maybe there's a letter from the shelter that says they've been residing in the shelter for this length of time. You can use HMIS to establish homelessness. So if there's a record of someone, you know, staying in shelter or being homeless and engaging with an outreach program, that would certainly work. If you can't establish third-party documentation, you may ask for intake worker observations. So, you know, like the secondary certification from whoever is serving the individual, or, you know, potentially like an outreach worker or someone else within the organization. And then if you can establish through any of those means, the final and sort of least preferred way to do this would be certification from the person seeking assistance, so a self-certification. And I see would the coordinated entry record establish third-party documentation for a shelter's eligibility? Andrea, yeah, that's a good question, and absolutely it would. The requirements for shelter are a little bit less than the requirements for the other programs. And I learned this because we had a finding related to this. In order for someone to come into shelter, they have to self-certify that they're homeless and they have no place to go. So for shelter, a self-certification, and how we solved this problem was essentially to do a sign-in sheet that said, by signing below, you certify that you have no place to go, you know, and that you are experiencing homelessness. So the record requirements for shelter are less, and a lot of that is because there's not, you know, as much rental assistance or kind of financial assistance going to those programs. So I hope that answers your question. If not, please feel free to follow up. So yeah, ideally you're getting that third-party documentation, which can include HMIS. If not, you know, you can accept a self-certification from folks. I think in certain circumstances that may make sense, and I don't think that the intention of this is to make it hard for folks to access assistance that they need, more just to make sure that you're serving people who have eligibility, if that makes sense. Okay, so we talked about this a little bit, and I think there were some follow-up questions. Yes. So for rapid rehousing, you're trying to establish that someone is, you know, is literally homeless. So Sally, your question, can rapid rehousing use HMIS record for the stay in emergency shelter? Yes, that's absolutely adequate. If you can demonstrate, for example, that that person has been in emergency shelter over the course of the last several days, or, you know, even has a stay in emergency shelter leading up to the time that they're presenting for assistance, that would work, that would be adequate. But you do want, you know, to be able to capture that information. So, you know, thinking about, you know, if you're not doing a paper file, but making sure that, you know, if someone were to ask for, let's say, you know, there's an audit that occurs or a monitoring that occurs from the city or from HUD, that you're able to establish that homelessness as part of the record. So just thinking about how you need to do that. HMIS systems are different, so just wanted to call that out. And so, yep, you know, as we discussed, and I see Whitney adding some detail here in the chat that may be helpful. As far as determinations of ineligibility, just make sure that you're documenting that too. I think that's something that isn't necessarily second nature. You know, generally you're thinking about people that you're serving in the program, but you do need to keep those documentations as well. And again, that could be an HMIS record if it makes sense. If not, you know, if you're not tracking that in HMIS, maybe if you're coordinated entry or something, you want to track it separately. So the second piece, as far as record keeping, is annual income. And I think my understanding is that while there were some homelessness prevention programs, those programs are not currently funded by the city, and that the focus right now is rapid rehousing. But just for kind of like general awareness, for program participants who receive homelessness prevention assistance or who receive rapid rehousing assistance longer than 1 year, documentation of annual income must be maintained. So anyone who's presenting initially for homelessness prevention, you need the documentation. For folks who are receiving rapid rehousing assistance, if you're serving them for over a year, you'd need to obtain and include in the file this verification. So what that includes is an income evaluation form. and source documents for the assets held by the program participants, in addition to income received over the most recent period for which representative data is available. So this would include a wage statement, unemployment compensation, public benefits, bank statements. I think another common one you may see is SSI, SSD paperwork, that sort of thing. There is a sort of, if you're not able to get source documentation for whatever reason, a written statement by a third party, so whether it's an employer, a government benefits administrator, that would be acceptable. Generally in this situation, they may be able to provide you with a pay stub. I think it's gotten easier, certainly, now that things are virtual, a lot of people may have a phone and they may be able to show you, or send you copies of their pay stubs, that sort of thing. So I would say, and Andrea, I see your question confirming whether the HMIS record of income, does that count as income? I think you're going to need that source documentation if at all possible. So I don't know how your HMIS system works. The one I was familiar with, you could upload additional documentation, but that HMIS record alone would not really meet the standard. You'd need something additional, and the preference would be that source documentation. So, the most recent pay stubs, or, their social security statement that they received recently. So I hope that helps sort of clarify. And if not, please feel free to follow up. I think, you also could even come off mute. I think no one is muted, so feel free to ask. And so the written certification is sort of the second option. So this would be the subrecipient or intake staff's oral verification by the third party. So, if someone says, yes, you can call my employer and speak to the HR department to confirm the income, you could gather it that way. Probably source documentation is preferable, but that will work. And then to the extent that source documentation and third-party verification are unobtainable, the written certification by the program participant of the amount of income received for the most recent period representative of the income for that program participant is acceptable. So just to put it out there, there is always an opportunity for self-certification, but it's not the preference. And I think many of you are aware of this as it relates to homelessness status, but also maybe income. But it is preferred to nothing at all. So, make sure that you're gathering those self-certifications if someone's not able to provide any additional verification, source documentation, or written certification. So continuing with the conversation about program participant records, in addition to sort of the homelessness status or at-risk status, and those guidelines regarding income, you also need to have the services and assistance provided to that program participant, including things like security deposit, rental assistance, and utility payments made on behalf of the participant. So you would need documentation of that. Also compliance with the requirements for providing services and assistance. And this goes back to the requirements that you'll find in the regulations. So, each program component has its own requirements and eligible activities. There's also the provision on determining eligibility and the amount and type of assistance and appropriate assistance and services. So essentially that's a lot to sort of take in, but you want to document, any financial assistance that you're providing an individual, and that includes also a lease agreement. You want to have that in the file. In addition, you want to make sure that you're documenting the services that you're providing and sort of any determination of the needed services or resources. So making sure that you have a file that sort of, for lack of a better description, tells the story of how someone's being served and why they need that assistance. And then, if there's a situation where you're terminating assistance because maybe someone's not meeting the program requirements, there is an expectation that you have a policy for that and that you follow that policy. So that can't just be, for example, a case manager with the rapid rehousing program decides that, you know, someone's not following the program requirements, or they're not showing up when they try to visit them in person, so they're going to close their case. You do need to have a policy there for how you when and how you terminate assistance, and you do need to follow it. So that's something to be aware of. And there is in the ESG regulations, there is guidance on what needs to be included in that policy. And if that's something that's helpful, I can certainly follow up on that. But I think actually this link sort of gives you the minimum requirements there. So when you get these slides, you'll have the information you need in case that's a policy that you don't currently have. Okay. So just to sort of reiterate the record retention details for the homelessness verification, the documentation of each program participant's qualification as a family or individual at risk of homelessness or a homeless family must be retained from 5 years after the expenditure of all the grant funds. So I think that's the bolded part, because that's the part that may get lost. It's not 5 years from the point at which you know, someone was served in the program. It's the time at which, you know, so your allocation for calendar year 2023, you need to retain those funds, or you need to retain those records for 5 years after those funds are spent. So important to keep that in mind when you're thinking about, okay, you know, we've got all these records, and you know, it's time to sort of figure out what we're going to do with them. I think it sounds like a lot of you are using HMIS for documentation, so that makes it easier. You're not dealing with, you know, like the physical files that can take up a lot of room, but do want to make sure that you have those details available, and that, you know, that could be something, for example, that, you know, if the city is monitored again by HUD, or if they're doing their subrecipient monitoring, you just need to have access to those records so that they're available as requested. I said that we would mention this briefly. It's I don't think it's entirely relevant, but I think just fully understanding the record retention policy requires that we talk about ESG funds for both the renovation and the conversion of an emergency shelter. So two things to know. First is that when ESG funds are used for the renovation of an emergency shelter and involve costs charged to the ESG grant that exceeds 75% of the value of the building, records must be retained until 10 years after the date that the ESG funds are first obligated for the renovation. And then secondarily, where ESG funds are used to convert a building into an emergency shelter, and the cost charged to the ESG grant for the conversion exceeds 75% of the value of the building after conversion, records must be retained until 10 years after the date that the funds are first obligated. So kind of a longer expectation, a longer requirement around record retention when you're talking about shelter renovations or shelter conversions. So something to be aware of. Just a little bit of guidance for retaining records in an electronic format. Recipients and subrecipients may store files electronically, but I think I sort of spoke to this, but must be able to produce records in a hard copy upon request, or allow them to be viewed as part of an on-site or remote monitoring. And so, you know, making sure that those are accessible is really important. If you use an electronic system, it must maintain an adequate backup system for the files and ensure that the privacy protections that are established are followed. So it can't just be, you know, these records are sitting on Steve's flash drive, and so they're available if someone needs them. That doesn't meet the standard as far as backup is concerned, but also thinking about privacy protections and you know, HIPAA violations, potentially, you know, people's sensitive information needs to be protected. So making sure that you're following those expectations is really an important piece of this. I won't go too much into this because I think we already speak to it, but you know, you do need to comply with all of the record requirements in 2 CFR 200. So this is not the ESG requirements. These are sort of the broader requirements that go across the federal government. And you also need to think about public rights. So you must, as the recipient, you must provide citizens, public agencies, and other parties with reasonable access to records. So there could be a public request for records, and you do need to be able to respond to that. And then thinking about another requirement that many of you are probably familiar with, but the recipient needs to collect data for the IDIS system. So that information also needs to be submitted to the system, and some of that, requires kind of follow-up from subrecipients as well. So thinking about access to records in sort of a broader sense. So that is record retention. And I don't know, I appreciate people asking questions as we went through things. So it looks to me like maybe all of those questions are answered, but please feel free to add anything in the chat. And what we're going to do is we're going to go to sort of the second topic, which we're going to discuss today, which is conflict of interest. So this is I think that in theory, conflict of interest is pretty straightforward, but when you start to get into individual situations, it varies a little bit. But a conflict of interest is an individual conflict of interest arises when an individual with specific relationships to the recipient or subrecipient can benefit financially or otherwise by the activities carried out in the grant fund. So this would include any decisions or activities made by a recipient or subrecipient that gives the appearance of impropriety. Identifying and documenting actual and perceived conflicts of interest is a mechanism used to ensure accountability of program funds. So if you believe that there may be a conflict of interest or there could be one that's perceived, those are things that you do need to identify. And there are situations where you can go to HUD to ask for approval or sort of their sign off on a potential conflict of interest in certain exceptions. So that is something to consider. But generally, you do need to think about these situations where there's indirect benefits to those folks who are providing the assistance. And then I think something to highlight here is that all subrecipients are required to have a conflict of interest policy. So again, if this is something that you don't have on an organizational level, you do need to create it. And I think it's also something where, there's some details about what needs to be in the policy. So we did give a link here to some additional guidance that you can refer to in 576-404 that will help to clarify that. Some additional considerations for the conflict of interest policy. Both the program recipient and subrecipient need to have the policies, and for both the recipients and subrecipients, the program needs to distinguish between two types of conflicts of interest. One related to organizations that carry out the project, and another in specific thinking about the individuals involved in providing services and day-to-day operations. So both types of potential conflicts of interest need to be called out, and there needs to be in the policy the ability to speak to both of those. And so, there may be a situation, for example, where someone is a case manager providing services, and maybe a family member, a cousin, a sibling, shows up seeking those services. And I think that would be a more specific kind of individual conflict of interest. And it would be the expectation that that person kind of steps away from providing assistance to someone that they know well or are related to. So something to think about. Those conflict of interest policies must be accessible along with records to show compliance with the policies. And this includes records supporting exceptions to any individual conflict of interest. So if you had requested an exception, you need to keep documentation of that. And again, this is really, making sure that you have it should you be monitored or should the city be monitored and request that documentation. And no covered individual who participates in decision-making may obtain financial interest or benefit from an activity, have a financial interest in any contract, subcontract, or agreement for either themselves or immediate family members or business ties during their tenure or the 1-year period following their tenure at the organization. So it's important to think about the different roles of staff at the organization and making sure that there's not the potential that they could obtain financial interest or benefit from any activity that's being provided. And as I mentioned, there's the opportunity to grant an exception on a case-by-case basis. This would need to be a request from the recipient. I think if you have that on a subrecipient level, I would ask the city for guidance on how you would address any potential need to request an exception. So a couple organizational conflict of interest examples. So one is when the provision or amount of ESG assistance is conditioned on an individual's or family's acceptance of an emergency shelter or housing owned by the recipient, subrecipient, or parent or subsidiary of the subrecipient. So an example of this would be a subrecipient offers rapid rehousing assistance to families experiencing homelessness, but they can only get assistance if they agree to move into a building owned by the subrecipient. And that could include like a parent company. So if you work at an organization that also develops housing or rents housing out, that would be a conflict of interest, particularly if you're requiring that someone move into that specific housing. But it also could have an appearance of impropriety if you are moving people in and that's their choice. So I think you need to navigate that as well. You need to document that and document that that's not the requirement to receive assistance. The second example is when a recipient or subrecipient carries out an initial evaluation for rental assistance when the individual is living in their housing. So kind of to follow up to that other situation, that initial evaluation to determine if someone is eligible, if that person is in a housing program or housing owned by the subrecipient or parent company, that sort of thing, that creates another conflict of interest. And so they would need to make a referral to another organization to serve that individual or household. So one organization can't be providing sort of the assistance and receiving the assistance. That creates a real challenge. So something to think about. I don't know how relevant this is to all of you, but it is a common thing for folks who are in the housing business to be in it in different ways. So something that you need to think about. And I think this is a similar situation, but another example would be an organization who owns rental housing and operates a homelessness prevention program. When someone gets behind on rent, they immediately refer them, they give them an eviction notice and immediately refer them to the HP program for assistance. So again, that's a challenge where you're reimbursing your own organization for that rental assistance. So that's a no-go. The other piece of this that we didn't talk about quite as much is also about the procurement process. So, there's a lot of requirements around procurement for HUD programs, but for the procurement of goods, supplies, equipment, or services, the ESG and COC program recipients and subrecipients need to comply with 2 CFR Part 200. There's a document that I linked at the bottom here that kind of helps with thinking about how to address this. This is pretty complicated when you start to think about procurement. So I think if you have questions about procurement, start with this document that I've provided, but you also could go to the regulations. And then the non-federal entity must disclose in writing any potential conflict of interest to the federal awarding agency. That would be HUD or the pass-through entity. So again, making sure that you're documenting any potential conflicts of interest as they arise, or if you think that they potentially could arise. So just another thing to think about as it relates to conflict of interest. So I think the best thing really is to create that policy if you don't already have it, to make sure that you're covered, and then to educate your staff too about potential conflicts. I think specifically on the individual level, like if they're engaging with someone who's experiencing homelessness who they may know or have a personal relationship with, so that they're aware of how to approach those situations. That's going to be the best way to just make sure that you're covered in this regard. So that is the story of conflict of interest as it relates to a number of different situations. And I know this one is, it's a little bit more complex, and sometimes it's hard to see how it relates to your day-to-day work. So strongly just encourage like having that policy in place and making sure that folks are aware of it. And so I think we're going to go on to the final piece that we're going to talk about today. And I don't see any questions in the chat, so hopefully that's clear, but if not, please feel free to add questions as they arise, or we can talk about them when we get to the end of the training. But we are now going to talk about duplication of benefits. And duplication of benefits was a specific consideration, I think, around ESG/CV. And that was because, you know, at the time that ESG/CV funds came out, many of you are probably aware there was a lot of assistance sort of, you know, coming to communities. There were the ARPA funds, there was the Treasury money that was helping with rental assistance. There was the market was sort of flooded with different assistance. And so there was a real consideration about, you know, serving people, and are they getting duplicative benefits, or are they getting benefits from a number of different sources that sort of exceeds the amount that they need for assistance. But I want to emphasize that like a duplication of benefits can still exist in other situations. You know, now that I guess that's officially called an end to the pandemic, that those resources are to a certain extent drying up. There also is the potential for a duplication of benefits in a number of different ways in sort of your regular work that you're doing with ESG and COC. So one thing to think about is if you have a partnership with another program, you know, maybe someone's providing the rental assistance, someone's providing the services, or, you know, there's any sort of agreement between organizations to serve folks. Making sure you're clear that, you know, on roles, so that there's not the potential for benefits to be duplicative. Also thinking about, you know, some of the other federal programs that exist. So I think a good one might be the SSDF program that, you know, functions pretty similarly to rapid rehousing. So ensuring that if you're serving a veteran, for example, that they're not receiving other federal assistance that could potentially be duplicative for their need. So starting there, but let's, you know, really quickly sort of define what a duplication of benefits is. And they call the duplication of benefits is also the shorthand is DOB, sort of like date of birth, but this time it's duplication of benefits. And this occurs when a person, a household, a business, a government, or other entities receive financial assistance from multiple sources for the same purpose, and the total assistance received for that purpose is more than the total need for assistance. So you want to make sure that there's sort of a clear line about the assistance folks are receiving, and also, you know, as part of your intake process, that you're asking about any other federal assistance that they're receiving, so that can help you make a effective determination about the amount of need that they have. So, you know, moving into the policy and procedure expectations for duplication of benefits, all grantees must establish and follow policies and procedures to ensure that a duplication of benefits does not occur. So thinking about, you know, what your process is to address that. And it might be, you know, something that's captured on your intake forms or on your reassessment, income reassessment, that sort of thing. And then these policies are applicable to CARES Act funding, which I know is not going to be continuing for the long term, but it's also any other funds that were used to prepare for and respond to coronavirus, as well as sort of like your general or annual allocation of ESG or COC funds. You know, so essentially when you're talking federal funding, there's the potential for and the need to check for a duplication of benefits. When you think about what that policy and procedure looks like, there are two kind of essential components. One is the requirement that any person or entity receiving assistance must agree to repay assistance that is determined to be duplicative. So that's you know, something that needs to be stated to the individual being served. And then having a method to assess whether the use of these funds will duplicate financial assistance that is already received or likely to be received. So making sure that, you know, as you think about your procedures here, that those two essential pieces are captured. So just really like high level in thinking about how you would analyze. And duplication of benefits. And this could be sort of the creation of your procedure here would be following these 4 steps. First step is to assess need and determine the amount of need. So, how much need does the individual have? So, if you're thinking about rental arrears, perhaps they owe $2,000 in rental arrears. And then the second step is to determine assistance. So the amount of the assistance that has or will be provided from all sources to pay for the cost. So, the first question might be, do you have any money to put towards the rental arrears? Second question would be, are there any other programs that you have applied for assistance from? I know I've seen in certain communities the requirement, for example, that maybe there's like a local fund for rental arrears that they apply and be denied before you would provide that assistance. And then the third step is to calculate the unmet need. So determining the amount of assistance that's already provided compared to the total need. And that amount, let's say they're receiving $400 of assistance from a local United Way or something like that. So then that unmet need would be, they had $1,000 of rental arrears, they're receiving $400, that unmet need is the $600 that's left. And then you want to document the analysis. So document calculation and maintain adequate documentation justifying how you arrived at the award that you're providing. So those are the pieces to think about as you're putting this together. So some examples of potential duplication of benefit concerns with ESG could be combining ESG financial or rental assistance with other subsidies. I think there's a clear potential here with COC rapid rehousing or permanent supportive housing. And probably all of you are aware of that you can't combine that assistance within those programs. Also, that financial or rental assistance cannot be combined to a household receiving the same type of assistance from another public source for the same time period, except at 6 months of the tenant's portion of rental arrears. Rental assistance may be provided to an eligible program participant who is living in housing developed with a low-income housing tax credit or other development subsidies. Note that development subsidies are not considered rental assistance under ESG, so they don't trigger this consideration. So if someone is in an affordable housing unit, they can still receive assistance. So that's a piece that's important to, you want to make sure that that's not a consideration for turning someone away. One other piece, which I don't think is something that's going to be relevant to most of you on a regular basis, but rental assistance may not be provided to program participants who are receiving replacement housing payments under the Uniform Relocation Assistance and Real Property Acquisition Act. So that's called URA, and it's sort of the requirement that someone who was in housing that is being renovated, that if they're moved out of that housing, that they pay for alternative housing for that individual during that time period. So I've linked to that in the document here. So when you receive a copy, you can review that if you have any questions about it. It is URA, we can do a whole 4-hour training on URA. So don't want to get too far into that. So that, very, very high level, that is everything that we wanted to cover. As I mentioned,